In this series of videos on drafting, pleading and appearances, let us look at how to draft a sale deed or else a lease deed. I think for the students, a lease deed would be much more easier than a sale deed, because most of us would have either stayed in a rented house or else we would have rented our house to someone else. So maybe we can take up lease deed. If you have not yet subscribed to our channel, kindly subscribe to our channel, and if you like the video, kindly press the like button and also share it with your friends. Now, there are certain prescribed formats, not formalities, formats, which are there for a particular deed, like it could be a sale deed, or else it could be a lease deed, or else it could be a mortgage deed, it could be any other agreement, where basically the first paragraph of the deed would always specify what is the deed or what is the document basically, and then it is entered into between whom, that is, it could be the first party and then the second party. So you will have to describe who is the first party and then you will have to describe who is the second party. As I have already told you, before you actually start writing, you will have to sit and think as to what you are writing, why you are writing. That is, a little bit of brainstorming is required. Now, in the case of a lease deed, let us assume that I am the person who is going to let out my property. That is, I am the lessor, and then there is somebody else who is going to take the property on lease, that is, who is going to take the property on rent. So that person becomes the lessee. So he is going to take the property on lease, and then I am going to rent out the property. So here the two parties that are involved is the lessor and the lessee. Normally, when you sit and think, what could be the terms and conditions of a lease deed? It is very simple. I say that I have got my property, I would like to let out the property to you. Now the next question naturally that you would be asking is, for how many days or how many months or how many years you would like to rent out the property. So period is involved. Then the next one would be, what is the consideration, like what is the rent that I will have to pay, when I will have to pay the rent. So you will have to you will have to finalize on the consideration. Then you will have to mention at what date, that is before 7th, before 10th or before 5th of each month you will have to pay the rent. Then after that there would be the electricity charges and then the water tax, water charges, and then the municipality taxes. Then the question is, who has to bear all these things? So naturally it is the lessee, that is the tenant, who will have to bear all these things. So that you put it in writing. You say that the lessee will have to pay the electricity charge and then he will have to pay the water charges, but municipal taxes will have to be borne by the lessor, that is by the owner of the property, because it is relating to the property. So naturally you will have to bear it. Then you come to the period, that is, you decide that after 11 months you are going to vacate, or after 2 years you are going to vacate, or after 3 years you are going to vacate, etc. Normally you also have one thing called as giving some sort of advance, something like a security deposit to the owner of the property. So that how many months it could be, like if the rent of the property is like 10,000 rupees, it could be 3 months of rent as advance, that is 30,000 rupees as advance. Then or it could be 6 months as advance, or 10 months as advance, so it could be 1 lakh rupees. Next question is whether the owner will have to give any interest on that security deposit, because now let us assume that I am giving 1 lakh rupees as a security deposit to the owner. If I had kept the same thing in bank, I would be earning at least some 7 or 8% from the bank per annum. So I am losing that interest. So you mention whether they will be entitled to the interest or he will not be entitled to the interest. Next is, after vacating the property, what needs to be done, like whether you are going to give back the advance prior to vacating the property, or after vacating the property you are going to give back the advance. So these things will be reduced to writing. Why it has to be reduced to writing? Very simple, because you cannot trust human beings. So today I will say that the rent is 10,000 rupees, you will enter the property, next month I will say that it is 12,000 rupees. So naturally there will be a dispute, and if at all there is a dispute, it naturally will have to take it to the court of law, and the court of law cannot give you a decision based on your oral agreement. So it is always better that it is in writing, because if it is in writing, then the court can arrive at a judgment. It can say that the lessor has made a mistake, or else the lessee has made a mistake, he will have to pay the compensation, blah blah blah. All those things can be decided by the judge. So it is always preferred that it is in writing. Now what purpose the property will have to be used? That is, a property will have to be, normally you can say that it has to be used only for the residential purposes and not for commercial use. And then once I give the property, the question is, can you give the property to somebody else? Like I let the property to you and then you sublet the property to you. Normally the answer is no. The owner will not allow you to sublet the property. Then because that person would sublet the property to somebody else. So it will keep on going. So naturally it is not allowed. I mean, it can always be entered in the agreement saying that yes, it can be sublet to somebody else, but with the consent of the owner of the property or else with the lessor of the property. Now, what is a property then? Property, you will have to mention what is a property. Now, let us assume I have got 4 houses. One house is in some area, the other house is in some other area. So, I am mentioning what is a property. Now, that will be mentioned in the schedule. We say that the schedule is the property bearing number 8, measuring 40 by 60, and then situated at second cross so and so area. Bounded on the east and then bounded on the west, north, south, etc. Because it is why we give the details of the properties, because so that it becomes easier for you to identify the property. Because later on you cannot say that no, this is not the property I was speaking about. I was speaking about some other property. Now, why these things is because when you go to the court of law is going to look at both the parties as a wrongdoer, or it will be non-judgmental, because it will not see who is right and who is wrong. It will merely go by the document. So, if the document is clear, then naturally it will help both the parties. If the document is not clear, then it is not going to help any of, or it will not serve the purpose of the drafting of the deed itself. So, now this is what would be there in the lease deed. Now, let us assume it happens to be a sale deed. Now, what will be sale deed? Very simple. You are going to sell the property. So, now who is the seller, who is the buyer? You will have to describe who is the seller, who is the buyer. And then what is the property? That is where the property is situated. What is the consideration? When the consideration will have to be paid? Whether it will be paid by cash or whether it will be paid by check. And whether TDS will have to be deducted. All these things will be mentioned in the sale deed. As I already told you, once you understand the purpose of the document and why you are actually drafting that particular document, then it becomes much more easier for you to draft the document. And very important thing is you should have already seen the document. That is, if you have come across n number of sale deed or else n number of lease deed, then it becomes much more easier for you to draft a document. So, the first thing for a student that he will have to do is he will have to look at the study material. You should not think that, okay, I sit and then I think and then naturally the sale deed would come out. No, it is not that easy. So, you will have to look at the document. You don't have to write anything. You don't have to read anything. You simply glance through the document. You glance through the document. That is, now let us assume it is a lease deed. You glance through the lease deed for a couple of times. Then naturally that language that has been used in the lease deed naturally will get into your head, and then you will be able to reproduce it. Now, let us assume that I am drafting a lease deed. How the lease deed would start? First one would be the heading. I will say that it is a lease deed or else it is a sale deed, whatever it is. Then I will say when it is entered into and by whom it is entered into. Now, let us assume I am saying that this deed of lease is entered into by and between Mr. X and then Mr. Y. If I merely say Mr. X and Mr. Y, now let us assume I say that it is between Mr. Rajesh and Mr. Umesh. There could be n number of Rajesh and there could be n number of Umesh. So, it is very much required that the description of the parties is very clear. Now, to make it very clear, what do you say? You say it is entered into between Rajesh, son of so and so, aged about to so and so, who is residing at so and so area. Because it is not possible that there is a Rajesh, the son of is also the same thing, age is also the same thing, and he is also residing at the same place. Like n number of Rajesh residing at the same place is absolutely impossible. So, you give a very clear description of the parties. So, you say this deed of lease is entered into on the 6th day of January 2021 by and between Mr. N. Rajesh, son of so and so, aged about to so and so, residing at. Now, this party, this lessor, you can call him as the lessor, the owner, the first party, etc., etc. So, within the bracket you say hereinafter referred to as the lessor, the owner, or else it could be the first party. So, if I am not there, if I am not alive, this agreement would also continue. So, it would also continue means you say it is first party, etc., etc., which also includes his legal heirs, successors, etc., etc. It means if I am not there, if I am not alive, that agreement would be applicable, or it would be binding on my legal heirs, on my successors. Then you come to the second party. Now, there is a owner, there is a tenant. That tenant you can call him as a tenant, or you call him as a lessee, or you call him as second party, whatever it is, but you will have to maintain the uniformity of language. Now, what do we say? It is entered into between N. Rajesh, son of so and so, residing at so and so, aged about to so and so, hereinafter called as a lessor. Then Mr. Umesh, son of so and so, or let us take Miss Geeta, daughter of so and so, aged about to so and so, residing at so and so, hereinafter referred to as the lessee, that is a tenant or else a second party, which term shall hereinafter include or legal heirs, the successors, etc., etc. So it means it is not only Geeta who is binding on that contract, it is also the legal heirs who are also bound by that particular contract. So the first paragraph is very simple. Here, there we say what is the agreement, we say lease deed, sale deed, etc., by and between whom. Then there you say first party, second party, etc. So if at all you are maintaining this first party and second party, it is always preferable that you maintain first party and second party throughout the document. Or if you are maintaining the word lessor and lessee, it is always preferred that you maintain the word lessor and lessee throughout the document. At one place you should not say lessor, and then the other portion you should not say is the first party. Then one more place you say lessee, then you say some other place you say second party. Now this is clear. Now the second portion or the second paragraph of the agreement is you are reiterating that the person who is letting out the property is the owner. So what do you say? There you say, whereas the lessor or else the first party is the absolute owner who is in possession of the particular property, and he thought of actually letting out the property, and the tenant, that is the lessee or the second party, approached the first party requesting him to let out the property. So now it is something like you are getting to enter into an agreement. Okay, now you have entered into an agreement. In that you will have to mention what are the terms and conditions of the agreement. Now what are the terms and conditions of the agreement? Normally you say that it is hereby agreed between the parties that what 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Some let us assume some 10 conditions are there, 8 or 10 conditions are there. Now what is that? First one is rent. It is hereby agreed between the parties that the rent of the property shall be rupees 5,000 per month. Okay, then point number 2, when you will have to pay the rent shall be paid by the tenant or by the second party on or before 5th of every month. Fine. Third point, there the tenant will have to give a security deposit. Then what do you say? It says that the tenant or the second party will pay 10 months advance or 5 months advance as a security to the owner of the property or to the first party, which shall be repaid upon the tenant vacating the property, and there shall not be, and the tenant shall not be entitled to any interest on that particular security deposit. Fair enough. Now what is the term of the agreement? The term of the agreement, let us assume that it is 11 months. Why it is 11 months? Normally you would have seen that many people enter into a lease deed only for 11 months. Why not 12 months? Why not 13 months? Because under the Registration Act it says if it is for a period of 1 year or more or year to year, then registration becomes mandatory. So if at all you do not want to register the lease deed, then what do? You do it for a period of 11 months, and again you go for a renewal, again go for a renewal, keep on doing this for n number of times. But if it is for 12 months or more, then registration becomes a mandatory. So without registration, that document would not have any legal validity. That is, it cannot be taken to the court of law. Then the court would say that we are impounding the document, you will have to pay the stamp duty, and then you can come back. So now normally you say that the period of lease is for a period of 11 months starting from January 1st, 2021. So after that period, the tenant will have to vacate the property, and once he vacates the property, then the advance amount of rupees 1 lakh or 50,000, whatever it is there, it will be given back to the tenant without any interest. So now this is one more clause which is there in the lease deed. Now after that, what could be there? Electricity charges, the electricity charges, water charges, and then the municipal taxes. Who has to bear this? You can write that the electricity charges, the water charges, etc. shall be borne by the tenant, or the municipal taxes shall be borne by the owner of the property. Now next, they may agree that after 11 months they may go for a renewal, but provided a 10% increase is given. So you can write that it is hereby agreed between the parties to the agreement that after the expiry of a period of 11 months, the lease deed may be extended. It is not shall be, because shall be means it becomes mandatory. So you can always say that it may be extended by mutual consent of both the parties upon payment of an additional rent of 10% over and above the rent that is being already paid. Then what else you can say? You can say that the property shall be used only for residential purposes, and it shall not be used for any commercial purposes. Then next, now we say all these 6. If we do not do it, then what? Now that question arises. That is, if you do not pay the rent, you do not use the property for residential purposes, but you are using the property for commercial purposes, then you can always say that in case there is a breach of contract by either of the parties to the contract, then the matter can be taken up to the arbitration, or it can be taken to the court. It depends on the parties. They can decide whether they want to take it to arbitration or they want to repudiate the contract, that is, they cancel the contract. So they can put that particular term in the lease deed. Now after that, After that, then you can also specify that the property that has been let out to the tenant or let out to the second party shall not be let, that is, shall not be sublet to somebody else unless a written consent is obtained by the first party. The first party happens to be the owner. Now, this is a very basic or else a very simple lease deed. So, if you want, we are not supposed to say this, being professionals, we are not supposed to say this. You want to charge more to the client, means naturally you can add some more clauses in the agreement, because even the client would be much more happier. He'll think that my advocate has given me a lease deed which is of almost like 10 pages, and you charge around 10,000 rupees, 50,000 rupees, you would be happier. You give him only 2 pages of document and you tell him that your fees is 10,000 rupees, he is not going to be happier. So, naturally you can add a number of terms and conditions that you please like. But the basic thing is only this: you will have to pay the rent, you will have to give the advance, and after the period is over, you will have to vacate the property and then hand over the property to the owner. And at the time of handing over the property to the owner will give back the advance amount that he has taken from the tenant. Very, very simple lease deed. Naturally, after that, both the parties will have to sign it, and then it should also be witnessed by the parties. So, you say when it was signed, you say that in witness whereof both the parties have put their respective hands on this particular day, that is on the day, year and month which is mentioned about because the first line you would have mentioned that this deed is entered on the 5th day of January 2021. So, again you do not have to repeat the day on which you actually entered into the agreement. You mention that. After that, very, very important is you will have to mention the schedule of the property, because what is the property that is being let out. So, you will have to mention the schedule of the property. Now, what is the property? You can say property which is situated at survey number so and so, street number so and so, and any area, etc., Mysore, Karnataka, blah blah blah, and east, bounded on the east by, west by, north by, south by. And if it is a property, you can also mention that there are 2 fans in the house, 3 geysers in the house, and then 1 wash basin is there. All these things can be mentioned. It is absolutely, it is just a precautionary measure, or it is just to safeguard the interest of the owner of the property. So, after that, naturally it will have to be signed, and then once it is signed, the deed gets completed. So, this is how you write a deed. So, it could be a deed, or else it could be a lease deed, or else it could be a mortgage deed. First is you understand why you are doing that particular document. So, why you are leasing the property? To get some money out of it. What is that money? We call it as a rent. So, who is the person who is entering into the agreement? Who are the parties? It is the lessor and the lessee, owner and the tenant, the first party and the second party. So, you mention all these things, then the deed gets completed. So, it is very simple. The only thing is you will have to come across as many documents as possible. You just go through as many documents as possible, then that becomes much more easier for you to draft an agreement or else a deed. With this method, I think you will be able to draft any deed for maybe a simple deed for that matter. If you want to learn more about the subject drafting, pleading and appearances, kindly fill the Google form given in the description box below. If you have got any comments or questions, kindly leave it in the comment section below. For more courses from Ekcel Academy, kindly visit excelacademy.com.